Good evening, everyone. I'm delighted to welcome you to our YouTube class on the topic POSH Act Overview and Practical Problems of Implementation of the POSH Act within companies. Tailored for students, this session delves into the intricacies of Prevention of Sexual Harassment Act. We will attempt to provide a comprehensive overview while addressing practical challenges encountered in the implementation of this crucial legislation and try to gain valuable insights into the legal landscape surrounding workplace harassment. And to this end, I am honored to welcome Mr. Lakshmikant Chaudhary, a seasoned legal professional with over a decade of experience in government, public, and private sectors. Mr. Chaudhary currently serves as the Senior Law Officer at Bharat Heavy Electricals Limited or BHEL and has previously held positions at Bajaj Alliance and ICICI Lombard. His expertise lies in insurance sector as well as labor and employment laws, and I'm certain that his insights today will be valuable contributions to our legal learnings. Thank you so much for being here, sir, and I look forward to an interesting and enlightening session. Thank you.
Thank you, Kashesh, for the wonderful introduction. And thank you for inviting me. Thank you for having me here. It's a pleasure to share our practical insights with law students. And LawSikho is really doing well. So, my best wishes for LawSikho. Can I start now?
Yes, sir. I'll just load up your slides.
Okay. Good
Uh,
evening,
le-
everybody. Yeah. Can I
Sorry,
start
sir. I
now?
just wanted to say they're visible now.
Okay. Okay. Good evening, everybody. As Kashish has already mentioned about the topic, today we are going to discuss about the POSH Act. Like the POSH Act, it is called the Prevention of Sexual Harassment Act at Workplace, Prevention, Prohibition and Redressal 2013. In short, we call it POSH Act. Since there are a lot of material available on Google and everywhere, so we are going to have a little bit of overview of the act, and I am going to talk more about the practical problems which companies are facing, and in reality people are facing in implementing this act. So before starting, I would like to have like how this act was evolved. So the entire credit of this evolution of this act goes to Honorable Supreme Court of India, who, which they have one judgment they have given probably in 1997, Vishaka versus State of Rajasthan. In this, Honorable Supreme Court has framed certain guidelines, like why, like how this workplace and why this issue has entirely arisen. So, if we go into the brief facts of this case, the case related to Bhavri Devi, who was working under the scheme of Sathini under the government of Rajasthan, which is under the Ministry of Child and Development. Bhavri Devi was entrusted with a lot of responsibility of creating awareness amongst the local villages about stopping child marriages, then creating awareness about education and all that. So probably in the year 1992, Bhavri Devi has come across one incident wherein one girl of around 9 months old, she was about to get married. So when this came to her notice, she tried to persuade the family, and when the family has not accepted the reasons of Bhavri Devi, family proceeded with the child marriage function. Somehow the matter went up to the police, and police intervened. The family members of the girl child holded some grudge against Bhavri Devi, and eventually it led to her gang rape. Then matter went it went criminally. The matter proceeded further, and lot of uh, impediments came in her investigation, and lot of hurdles she has faced. And what we last saw is that it ended up in acquittal of the accused, with a statement saying that by honorable court stating that the member of upper caste, it is unlikely that member of upper caste can gang rape a woman of lower caste, and that too in presence of her husband. With such bizarre reasoning, the acquittal was given to accused. The matter proceeded further with High Court, and thereon one NGO named Vishaka. They filed a writ petition under Article 32 with the Honorable Supreme Court of India. In that, Honorable Supreme Court has recognized and has taken this Bhavi Devi incident on record, but not with the criminal angle and all the procedure angle, but they recognize the right that what all obligation Constitution entrusted for protection of women. So certain guidelines were set in Vishakha versus State of Rajasthan, which we call the it took birth. So why I am referring to this case is that Bhavri Devi attracted she attracted ire of a rapist solely on the basis of her work. Bhavri Devi's legal battle has led to this, uh, what we say, it birthed sexual harassment protection laws for women, and these are the which formed the backbone of guidelines passed by Honorable Supreme Court of India. This judgment was passed in year 13/8/1997. Since it was specifically stated by Supreme Court in the judgment, till the time no legislation will come, these guidelines will hold the field. After that, matter continued, and many organizations, at their whims and fancies, they have implemented. Government organizations and public sectors, they are somehow trying to implement in one way or other. Then one more case came up before Supreme Court in the year 2012, Medha Kotwal versus Union of India. In this case, the petition was specifically filed complaining that the guidelines issued by Honorable Supreme Court in Vaishakha versus State of Rajasthan has not been implemented. Honorable Supreme Court issued notices to many states and found that there's lack of implementation of this act. And Honorable Supreme Court reiterated that government organizations and PSUs they should amend their rules in accordance with the Vishakha guidelines. Further, if you see from 1997 to 2012 onwards, these guidelines were holding the field. Then somehow pressure was mounted on government to frame laws for protection of women at workplace. So a draft bill named the Protection of Women Against Sexual Harassment at Workplace 2007. This was issued by our Ministry of Women and Child Development, Government of India, and suggestions were invited. So if you see the timeline, 1992, Bhavri Devi got raped, gang raped in that incident. 1997, Vishaka guidelines comes into picture. These guidelines hold the field till 2012. After 2012, like prior to 2012, simultaneously government has implemented one draft was introduced, draft bill. That bill was named as Protection of Women Against Sexual Harassment at Workplace Bill 2007. If we go further, this draft bill was introduced in the Lok Sabha on 7 December 2010. So if you notice, in 2007, sessions were invited. 3 years it was with government, and consultation was taking place at lot of at various levels. And on 7 December 2010, this bill was introduced. When this bill was introduced, it was known as Protection of Women Against Sexual Harassment at Workplace Bill 2010. After introduction of the bill was referred to Standing Committee on 30th December 2010. Then Standing Committee examined a lot of suggestions, secretaries of Ministry of Women and Child Development, and the detailed report was completed and tabled in the House on 8 December 2011. Then after the perusal of Standing Committee's report, Lok Sabha passed the bill on 3rd September 2012. Matter was sent to Rajya Sabha, Upper House. There, Rajya Sabha passed the bill on 26 February 2013. Honorable President of India gave assent to the bill on 22nd April 2013, and the Act got published in the official gazette on 23rd April 2013, and on same date it got implemented. So if you see the evolution of this Act, story begins from 1997 when Vishaka guidelines came into picture, and in 2013 finally the Act saw the light of the day. So it is very important to know that in our country, and whenever a law has to be formed, especially when there are guidelines available in form of Supreme Court judgment, the process is very slow and it takes a lot of time, or it takes a lot of consultation at various levels. Then government gets changed, every government has their own priority. So this bill saw light of the day in year 2013, and today we are standing in 2023. So a decade has passed, so we will throw a light and understand that how this act was passed in 2013 and so far how much it has how implementation has happened, how much effective implementation has took place. Further, I would also like to mention about Justice Verma committee report here. If you remember in 2012, Nirbhaya gang rape case, in that during that case, there was a huge demand and huge pressure from the public that there should be some amendment in the criminal laws, and government has formed three-member committee headed by Honorable Justice Verma. He was a former Chief Justice of Supreme Court, and in that report also lot of changes were introduced in criminal laws like related to rape, sexual harassment, and that recommendations of the report led to the formation of Criminal Law Amendment Act. This committee was formed on 23rd December 2012, and the report was given by committee on 23rd January 2013. In this report also, Justice Verma committee has discussed the need for immediate implementation of Sexual Harassment at Workplace Act. Why I am mentioning this committee report here is because if you see the report was tabled on 23rd January 2013 and POSH Act was passed by Rajya Sabha on 26th February 2013. So the dates are very important that there was huge pressure was formed on government and parliament at that point of time to pass this law. Moving further, at present, the laws which govern sexual harassment in the country is this act, the Sexual Harassment of Women at Workplace. It is known as Prevention, Prohibition and Redressal Act 2013 and rules made thereunder. Then there are provisions in the Indian Penal Code 209, 354, 376, 509, and there are industrial employment standing orders also. There are some provisions there also, which gives ample protection to from sexual harassment. Now, talking about this law, the Sexual Harassment of Women at Workplace Act, in short, we call it POSH Act. Now, question arises that why this act was there when already FIR can be lodged under criminal law. So we have to understand this act was passed. It is an additional remedy available under the law, other than criminal and civil remedies. So it need not that woman it has to go through this law only. It is a choice given to her. If she wants, if she's working, she can approach the mechanism available under this law. She can approach police separately, and she can approach civil court also for compensation. So this law gives an additional remedy other than civil and criminal remedies available under law. The basic feature of this act is enacted in section 28, which says that this act has no overriding effect. It is not derogatory with other laws, so it has to be read in consonance with the law. The term was not used that notwithstanding anything contained herein. It's very clear this law has no overriding effect. So this law has to be read along with other laws, and if any overlapping is happening, depend upon the situation and it can be implemented. Then this law gives two committees are there in this law, which is one is called ICC, Internal Complaints Committee, another one is called Local Complaints Committee. So the committees which has been given power under this law, they have the power of civil court. So it is a very powerful committee. I think it is the only committee available under the law, internal committee, which has the powers of civil court. And any appeal from this will generally lie to the courts only and not to any departmental level. So talking about ICC and LCC, the powers, why this is important is because, and why this mechanism has been formed, is because there are a lot of obligations are there under on us. When court have passed this, a lot of constitutional obligations are there. So when we will read the preamble of this act, we'll understand. So the crux of the POSH Act is very clear. No woman employee shall be subjected to sexual harassment at workplace. So this is the crux of this act. So one thing we have to understand very clearly that this act is only for women employee. Okay, and it is not for men, only for women. So harassment faced by women from men or women from women can be reported under this act. Then this act has 30 sections and 8 chapters. So the arrangement of sections are given in a very different manner. So we have to logically understand how this act flows. So first and foremost, we'll go to the preamble of this act. So preamble of this act consists of 5 paragraphs. Para 1 talks about the purpose, that is redressal of complaint of sexual harassment. Para 2 talks about our constitutional obligation. In our constitution, there are provisions which gives ample protection to women, like Article 14, which says right to equality. Then Article 15, there should be no discrimination on the ground of sex. Article 19(1)(g), right to trade and profession. Article 21, right to life with dignity. See, we have to understand that all these provisions are meaningless if no actions has been taken on them by the government or by the legislature. So, though these provisions were there under the law, and these are fundamental rights, and fundamental rights gets enforced by Supreme Court under Article 32 in the Vishaka guideline. So, whatever Vishaka guideline Honorable Supreme Court has passed, they have enforced the fundamental rights which are available under Article 14, 15, 19, and 21. Moreover, preamble, the third para of this preamble of this act, it talks about a lot of international obligations which we had. India ratified many treaties and international conventions where it is mentioned that we will avoid all forms of discrimination, especially in context of which to encourage women employment. So the preamble gives a very clear picture of this act, and there are a lot of material available with the government when they were passing this law. There was judgment of Vishaka, there was standing committee report, lot of evolution that happened. So all these were incorporated as it is, and lot of changes government has also suggested. Proceeding further, we have to understand what is the definition of sexual harassment. In a simple way, if I say, as stated here, any unwelcome act or behavior, sexual in nature, it's a sexual harassment, and it is a very subjective experience. And what matters is impact and not the intent. So accused cannot say that I have not intended it that way. Okay, the situation is other way around. It is like how much impact it causes in women. Basically, so a simple act of comment, a simple act of joke may be taken differently by different people. So it is a very subjective experience. So somebody who is not comfortable, if a woman is not comfortable with any particular statement or any particular thing, so it becomes very subjective experience. So in a simple term, if I say it is any unwelcome act which is not appreciated by anybody, or behavior which is sexual in nature, and it's a subjective experience, and the impact that matters, not the intent. So if we have to understand legally what is the definition of sexual harassment, under section 2N, the definition is given, but we have to read that definition along with section 3.2 of the POSH Act. Then only the definition will get complete. We cannot read it in isolation. Under POSH Act, various things has been defined at various level. We have to link them and we have to understand. So if we read section 2N is the basic definition of sexual harassment, and section 3 subclause 2 includes an advanced definition. So first we'll refer to section 2N, sexual, which talks about the basic definition. Sexual harassment includes physical contact or stalking, abusive sound, making sexually colored remarks, using sexually abusive language or signs in the presence of women employee, showing pornography or the likes, stalking, vulgar indecent jokes, phone calls, text messages, emails, physical confinement or touches against the will and likely to intrude upon one's privacy, demand or request for sexual favors. See, I have elaborated it a little bit here, but this definition of section 2N is consists of 4 things only: physical contact, sexually colored remark, showing pornography, and any other act. So if you see, this definition is quite inclusive. And moreover, if you see, section 354A of IPC also defines sexual harassment. So that definition and this definition is almost similar in nature. It consists of 4 ingredients that consist of 5 ingredients. So basically it's almost same. So if you see, Justice Verma committee, when they recommended amendment in criminal law, they have referred to they have referred to Vishaka judgment, they have referred to standing committee report, and they have almost made the definition similar. The only thing is the standard of proof under criminal law is quite high. So there, victim has to prove beyond reasonable doubt. Whereas here, only based on preponderance of probabilities or on available matter or on available incidents on record before the committee. The judgment has to be made. So section 2.1 talks about very basic definition of sexual harassment. Immediately after this, you have to read section 3.2. Then only you'll understand the context. Section 3.2 talks about advanced definition. So here it says implied or explicit promise of preferential treatment in her employment. So generally, when you have a colleague and he is man and you are a woman, so in that, if a man is getting preferential treatment than you, impliedly or explicitly, so that can be called out as a sexual harassment under this act, because you have to judge the performance of your employees based on the merits and based on the work and the tasks they are completing, and not based on the gender. Implied or explicit threatening treatment in her employment. Here, tit for tat means like if you'll not do this thing for me, then this thing will not be given, or you'll not able to get promoted, or you'll be thrown out of your job. So such kind of threatening treatment in your employment, in implied or explicit manner, also amounts to sexual harassment. Third is implied or explicit threat about present and future employment status. Same as I mentioned above, like a threat to women. In many cases, it has come to my notice, like I have got to know from a lot of people, that if the woman will not listen or will not agree to the terms of their bosses, then and when she resigns from one particular company and when she joins a new company, then the messages is passed generally to other company also, that about her character, that this woman is like this and she is like this. So it's very easy to put a word and say bad things. So such kind of threats also amount to sexual harassment. Then creating hostile work environment for them. See, creating this hostile work environment is a very wide definition, because what happens that if you create circumstances in an office, it is very difficult for a woman employee to focus on her work, and she'll be worried about this thing only. So it will ultimately affect her productivity, and then giving it a color of interfering with the work unnecessarily. So this amounts to creating hostile work environment is also part of sexual harassment, and humiliating treatment, which will likely to affect her health or safety. So such humiliating treatment, like shouting her in front of people, which is not an isolated incident, but it has some history associated with it. So such incident also has a very bad impact. And all these incidents earlier were used to be called a regular job thing, that boss used to scold their employees, and this used to be considered as normal. But when this act was introduced and legislature specifically called it out as sexual harassment, it gives a lot of weightage to the rights of women. So it's very important that once, if you have to understand the definition of this, and this definition is inclusive in nature. This definition is not exhaustive under the act. So if you see the bare provision, it says and any other thing. So when this line comes, and in previous, if you say any other issue, it gives the definition very inclusive meaning. So that relation we have to understand, that section 354A of IPC has a similar definition of sexual harassment. Section 2.1 read with section 3.2. This is a basic definition, section 2.1, and section 3.2 is advanced definition. So you have to understand it in a broad perspective. So if going further, like we have to understand this also, like in the definition clause, there are a lot of one definition is given, that is aggrieved woman. So who is generally an aggrieved woman? So they say woman of any age. If you read the prior provision, it very clearly says woman of any age comes under the aggrieved woman. So how a complaint has to be filed. So it gives a very broad definition for employee also. It gives there are 16 definitions given in the section 2, but for the purpose of understanding this act, we have to see 3 4 definition, which will be helpful for us to understand. Definition of employee, definition of employer, then definition of aggrieved woman, definition of respondent, definition of appropriate government. All these definitions are given on the thing. So once this offense, we understand the offense of sexual harassment. Next thing we'll go to the definition of aggrieved woman. Who is an aggrieved woman? As per act, like since this act is specifically for women, so any woman who has faced all the incidents which is mentioned in section 2N and 3.2, she becomes the aggrieved woman. Now there are two types of aggrieved women. Okay. Now under this sexual harassment act, the complaint may be against two type of people. One, either with the employee or with employer. Okay. Employee means it may be your colleagues or subordinates, and employer means head of the unit, head of the company or head of the organization. So under this act, internal complaints committee is there. So and local complaints committee is there. Under internal complaints committee, complaint can be lodged against employees. But if a complaint is against employer, it has to go to local complaints committee. So we have to understand this very clearly that I'll just come to internal complaint committee. Every employer needs to constitute ICC as per the provision of the Act to take care of the following matters: to conduct inquiry into the complaints of sexual harassment, to make recommendations to the board of directors of your company in the matter of sexual harassment after conclusion of inquiry, to file annual report as per the provisions of the Act. So one thing we have to understand: if the complaint is against employee, you can file it under internal complaints committee. But if the complaint is against employer, it has to go to local complaints committee. So under this act, there is a provision for internal complaint committee and local complaint committee. Internal complaint committee, the word itself suggests it is a committee within the organization. And the composition is also mentioned in the act, which says that it should consist of one senior female employee who has power to implement and execute the decisions so that the committee's work cannot be interfered. Then minimum it says minimum it says two member and one NGO member, and half of the members should be women employees. Half of the members should be women employees, and one member should be NGO. NGO means external member. So the committee has been composed in such a manner so that it should give inclusivity, and maximum women should be there, so that when a complaint is lodged before committee, woman who is lodging a complaint, she should be comfortable in telling her things. She should be comfortable in sharing her audio. And one NGO member is inducted with the purpose so that the committee should be free from any internal pressure, and a message should go that it is externally being monitored as well. So this internal complaint committee is formed within the organization. Then there is one more provision of local complaints committee that is formed at a district level. That is not formed inside, it's a district level. So that committee is consist of district officer to whom notification is given. It's a government committee. It consists of one member, ex officio member of Ministry of Women and Child Development, of that who generally is secretary there. Then it consists of two other members from the background of SC, ST, OBC, and other backward classes. Then it also consists of one member like who has knowledge of legal and NGO and sexual. So there the composition is 5 people. Here the composition, minimum composition is of 3 people or 4 people, and these are minimum requirement. The committee may be formed in a higher consist of higher people. So once ICC is formed, and it is mandatory under the law that ICC should be formed, then awareness should be made within the organization that so and so committee exists. Proper contact details should be given, that in case of any grievances, complaint should be filed with them. And in the same manner, local complaints committee, which is there at district level, which is there at tehsil level, which is there at taluka level, such committee should also display, and it should be known to general public that there exists such committee. So the distinguishing thing which we always have to remember, that if there is a complaint against employer, it cannot be filed with internal complaints committee, because since the committee is internal in nature and the employer being owner of that particular organization, it's easy for him to influence the internal complaints committee. So the complaint will always lie with local complaint committee. Then if proceeding further, the act which is mentioned in section 2 and 3.2, that act is committed, and with whomsoever it happens, woman, she becomes aggrieved woman. Aggrieved woman can file a complaint with internal complaint committee. Now this is one of the remedy. Why the purpose of this internal complaint committee is that since the woman can go to police station as well, the woman can approach courts as well. But Honorable Supreme Court have thought that since it is very difficult for women to narrate her ordeal and facing things at police station because police works in their own procedural way and courts work in their own procedural way, they wanted to give a mechanism which is very approachable and available at her footsteps. So if something like this is in organization within organization, it is easy to access, very easy to tell. And plus, court have also given this legislature have also given this committee a power of courts. So this becomes a powerful committee and accessible as well to women employees. So that is very important here. So a complaint can be filed with ICC. Since we are talking about companies and corporates and this sector. So we will focusing upon internal complaints committee. So what it says that complaint has to be filed in writing. If you see in CRBC under section 154, if you go and register FIR, it may be in oral or it may be in writing, and it is the responsibility of a police to reduce it into writing. But in the present case and in this act, it is mandatory that an aggrieved woman may make a complaint in writing with any member of ICC. So the complaint has to be in writing. No oral complaints will be entertained. Okay, complaints may be made to any member of ICC or a nodal officer may be appointed within a company, and his prescribed contact details are published at conspicuous places at company within company so that it is accessible. Then there is a limitation under the act. It says that the complaint has to be preferably within a period of 3 months of the date of incident. If there are series of incident involved, then it should be given within a period of 3 months from the date of last incident. So committee also has power to condone it up to 3 more months if suppose it get delayed and the affected person is unable to gather courage and approach. So committee may condone further it for 6 months, but beyond 6 months, it will not be taken up. So that's why if you see in Me Too movement, when Me Too movement got started, that time very old cases were being pointed out, and all the ICCs who've been appointed like inside the committee couldn't take the cognizance of the same because they are very old complaints. So that is one of the reason why ICCs have not acted on that complaints. Then there is a requirement that complainant should file minimum 6 copies. The assistance can be given for them, and it is very important that complainant should identify the person who is harassing her, or in this act, it is named as respondent, and she should be very clear about date, details, incident of sexual harassment, name of witness, supporting documents, like whatever is possible, whatever she remembers. Anyway, the committee is going to examine each and every factual aspects of it. So this is the procedure of filing complaint under the Act. So, so far we have read the definition of sexual harassment, then agreed woman, then formation of ICC and lodging of complaint with ICC. Now, once a complaint is lodged with ICC, ICC will understand, will apply its mind and understand the gravity of the complaint. And as per the provisions of Act, there is one more step for ICC to implement, that is conciliation, as mentioned in section 10 of the Act. This ICC will try to settle the matter at this level, but what law says, it is only at the instance of the aggrieved woman. If the woman, she is ready for settling the matter, and at her request only, committee will take steps to settle the issue. Like they may counsel both the parties and they may counsel the respondent, and they must close the issue then and there only, or they may make some terms of settlement. But law expressly bar monetary settlement for that. It cannot say that okay, so you give respondent should give so and so money to complainant and then matter should settle, because that will not look, it will not look nice, because settling a sexual harassment complaint for monetary thing, it gives a very wrong message. So It may consist of other things that the respondent will not repeat this act further, or the respondent is posted somewhere else. So, or teams are getting changed. All these steps can be taken, and settlement terms can be there. Suppose if settlement happens, committee will record the settlement and forward it to employer. And if and both the parties will be asked to oblige by the same. And if it is found that any terms of settlements are violated, then committee may start the inquiry again or may refer the matter to police, like whatever course, depend upon that. Suppose if conciliation is not taking place, then the next step for the committee is to conduct inquiry, to proceed with the inquiry. So if committee decides to go with the inquiry and during pendency of inquiry they feel that some interim steps is to be taken necessarily in order to perpetuate the matter further, like suppose if the complainant and the respondent they are of the same team or probably on the same vicinity, sitting in the same vicinity, or in whatever way they are related. So interim steps committee may take, like they may transfer the complainant or they may transfer the respondent to some other section or some other department, so that the interaction can be avoided. They may send the complainant on a paid leave, like whatever she is comfortable. And the law says any other method, any other available thing, any other which the committee feels. So there, wide power is being given to committee, depending upon circumstances, depending upon the facts, depending upon the situation. Committee will take a call, and some interim steps committee will take, and they will pass some interim orders, like pending inquiry. All this can be implemented with immediate effect. Further, the committee will start with the inquiry. They will call the complainant, they will call the respondent, they will examine them, they will put questions to them, they will verify the documents, they will visit all the places where things have happened, they will interact with all the witnesses, they will record statements of everybody, and based on that, they have to make a report. Now, the committee may make a report stating that the allegations of sexual harassment are proved. Committee may make a report saying that allegations of sexual harassment does not prove. So if it is getting proved and committee comes to the conclusion that yes, the complaint given by the complainant has substance and with all the available materials on record, it is getting proved that sexual harassment has happened, then whatever service rules are applicable to that employee, based on that action can be taken on him, and the consequences may be severe. It may be termination, it may be reducing to one rank, less rank, demotion, or or monetary compensation or reduction in salary, like whatever the service rules of that particular organization says. So based on that, committee will give recommendations, and based on that recommendations, employer has to implement it. It is binding on the employer. The committee's recommendations are binding, and employer cannot intermeddle with that. Secondly, if the committee recommends that the allegation of sexual harassment is not proved, then under section 14, it will be examined whether the complaint is not proved because of lack of evidence or it is a false complaint. So if it says that it's a false complaint, then action will be taken on complainant as per the service rules of the organization. So that has to be very clear. But yes, just because the complainant is not able to produce evidences on record does not mean that the complaint is frivolous. So proper application of mind has to be done. Once this complaint culminates into recommendation by committee, then report will be sent to employer and recommendation will be implemented accordingly. So this is the way procedure of sexual filing of from filing of complaint till examination of witness, then conciliation, and culmination to reports recommendations. Once recommendations are given to employer, employer has to implement it as it is, and there is no applicable mind. Further, there is a provision of appeal. If any of the party, the option is any of the party is aggrieved with the report of the committee, they may challenge it in the court. Please remember, they may challenge it in the court. It cannot be departmentally, it can be appeal be filed. Like in many PSUs, in their disciplinary matters, they have appellate authorities. They have disciplinary authorities, and any action taken by disciplinary authority will be challenged to a senior officer, which is called appellate authority. But the law is very clear here. This says any recommendations or any grievances from the report, it will be challenged in the court. Which court? If your service code prescribes any particular court, that court, or it will be a court of first instance generally, wherever it leads to. If it's a civil action arises from there, or it may be a writ. So it depends. So, but appeal will lie to court only. Why this act does not prescribe departmental appeal is because the committee has been entrusted with the powers of court, and when the recommendations of the committee gets challenged departmentally, so the appellate authority should also have the powers of court, and that too of higher court. Then only this will fit into the mechanism. So, what law says, if the committee has been given a power of courts, th- then it should ordinarily be lied to the original courts and not the departmental appeal. In fact, there is a judgment of Madhya Pradesh High Court which says that the act is silent, that departmental appeal on the provision of departmental appeal. So many PSUs they commit mistakes there whenever any report of sexual harassment comes and recommendation comes. So and they pass any order at disciplinary level, the appeal will be filed at departmental level. So that is incorrect because law specifically says that as per service rules, whichever court name is mentioned, if no court name is mentioned, then it's the court of first instance. So this is the entire procedure from filing of complaint till culmination of proceeding. Now there is certain responsibilities on the committee. Confidentiality has to maintain, and it is not only the confidentiality of complainant only. It should be the name of respondent, the name of witnesses, and the report has to be kept confidential. And this obligation is there on committee. And if there is any violation, there is a penalty for it. If we proceed further, once appeal is filed, then the matter will go in its own course. If like wherever the complainant wants to pursue or the respondent wants to pursue, it will go to that. Certain provisions under the law is very clear that employer has to form an ICC, then annual reports has to be sent. Then there are three responsibilities. First, it is responsibility of ICC to send annual reports to district officer. The district officer in turn has to send to state government, and the employer also has to send a report to district officer. This is what the provisions under Act says. Further, if you say that who is eligible to file a complaint, then there are various nuances instances being given, like agreed woman herself, and where she is unable to make complaint on account of her physical or mental incapacity, a complaint may be filed. A complaint may be filed by any prescribed persons on her behalf. Well, then there is next situation when she is unable to file, then it may be filed by any other person with her knowledge, with her written consent. And it is not the case that if aggrieved woman dies, the cause of action will also die. The complaint may be filed by any person who has knowledge of this incident with the written consent of her legal heir. So, the entire purpose of this act is to form a mechanism at workplace itself so that it can redress the situation there itself, and a mechanism which is accessible to women employees. So, the entire provision of this the act, POSH Act, is to make it convenient for women employees to get their issue redressed within the vicinity. This inquiry procedure we have already committed. Then we talk about the punishment. Whenever a recommendation of committee is given, the employer has to act on that recommendation, and any findings of the committee, if it says allegations are proved, it will be considered an act of misconduct in accordance with the rules. We have already discussed that. And other provisions are also given. to deduct such amounts from the salary or wage of the respondent as may be considered appropriate. Then it is not the case that if woman has approached under this act, she cannot pursue other remedies as well. Under section 354A, sexual harassment is defined. A complaint can also be filed there, and it can be taken with a criminal. Like police will file charge sheet, and it will follow the course in criminal code. Yes, the very important issue which we have to talk here is what is the punishment for malicious complaint or false evidence. Section 14 of the Act talks about this. They says that if the committee finds that the complaint which has been raised is a malicious or a false complaint or a false evidence has been given, then appropriate disciplinary action will be recommended against the women employee as well. So this is given to keep a check on, like, no, because see, whenever any law is made, their misuse is also rampant. So in order to curb that, this is just kept as a safety wall so that malicious complaint and false complaints with the false evidence can be avoided. So coming to the next one, this is the basic thing which we talked about the act, like what ICC is, how ICC functions, what are the responsibility of employers, and awareness camps has to be should be promoted within the companies. What are the practical problems which companies are facing in implementation of this act? See, first of all, there is no monitoring mechanism. If you see, Vishaka judgment was passed in 1997, and the act saw the light of day in 2013. That time guidelines were there, but there was no monitoring mechanism, no data to keep track, like how many people are getting in, how many complaints are getting solved. So this act comes with a format saying that they have to report. Annual reports are there, but state governments and appropriate governments, they have failed to make any mechanism where this can be reported and it can be challenged. Like if I say it in a simple way, in how many cases till date companies have received notices from government that they have not filed, that no ICC has been formed, complaint has not been properly dealt. Few cases are there where women approached courts, and during the course of proceeding it transpires that no ICC is there. If you see recently in news, there is a news of wrestling foundation, women, female employee, female from wrestling foundations who are wrestling champions. They sat on Dharna in Jantar Mantar, alleging sexual harassment charges against the chairperson of Wrestling Foundation of India. It came to light that there was no ICC in the Wrestling Foundation. So, despite Wrestling Foundation being government body, there was no ICC there. So, whenever such issues were taken up in media and issues were taken up with the court, then only it comes to the notice of court that there is no ICC. So this is the problem. The monitoring mechanism is not there. So gradually, we have noticed that few governments have started making online to file a compliance report, to file the report of ICC, to file not ICC report, to file the ICC notification that who are the ICC members, and annual compliances. Under the law, there is a provision of penalty also, and the penalty is very grave. It says that 50,000 rupees penalty will be charged on first instance. Second time, if it comes to notice, then double of that will be raised. Third, license will be cancelled. So their provisions is very much there, but it is yet to be seen the light of the day that how many companies' license got cancelled for not implementing this law. So I would point out that first and foremost problem is monitoring mechanism was earlier also not there. Nowadays, recently, few state governments have come up with some other option, but it is not effective the way it should be. Second, which I say will be lack of expertise of the ICC. See what happens, especially in private sector. An employee usually stays in the organization for an average of like 2 years or 3 years. Act says that average tenure of ICC should be of 3 years. So it will be difficult for like those employee who's hardly in the employment for a like for small time to become member of ICC. So ICC committee will keep fluctuating based on that. Secondly, in private sector, it has have got to know that many side like many times whenever a complaint is filed, HR with the apprehension that you'll be terminated and all that, the employee is made to like the respondent, whosoever he is made to resign. So private sector people hardly get a chance, like employees hardly get a chance to, like ICC hardly get a chance to conduct any matter. Very rare ICCs were set up, and even if it is set up, then cases will be tried by them. It's very rare. Yes, in PSUs and government sector, since people stay longer, usually they stay till the age of their retirement, and usually any such complaints or any such thing you'll find in this type of setup, government setup, PSU setup. So there you will see formation of ICC, functioning of ICC, cases are tried by ICC, reports are challenged before High Court. If you see many writ petitions before High Court where reports are challenged, matter more or less pertains to state government, central government organization. Very rare I found that private sector ICCs were there. So this led to lack of expertise of the ICC. But yes, I would also like to say that in private sector, probably ICC is more active in creating awareness. Like they will conduct workshops, they will disseminate a lot of information, awareness information through corporate communication channels. So that thing they are very good at. But yes, lack of expertise is always there. Even if sometimes like ICC is there, it is noticed usually that ICC members are lacking expertise because ICC is being given the powers of court. It's very difficult to explain if a person is from non-legal background to understand like how a power of court is to be implemented, how a punishment can be given. So all that nitty-gritties are there. So for that, Act says that proper training is important for all the ICC members. So employer has to do some investment on this training aspect, and then this problem can be cured. Second issue which I say about is confidentiality. See, maintaining confidentiality is mandated by law. It is not a matter of choice. If confidentiality is not being maintained, it is one of the ground of removal of the ICC members. If you see the act, there's a specific provision which says that if confidentiality is not being maintained and information is being disseminated, then ICC members can be removed on that ground. So it is a obligation of both employer as well as ICC member to maintain the confidentiality. But in a small setup in companies, usually everybody comes to know that so and so complaint has been filed against so and so person, and so that talks are there in the air. So this hardly see the reality, practical aspects of it. So confidentiality, though on paper it is there, but we hardly find that somebody is being uh, punished for breaching the confidentiality provision. Third, what I would like to say is that since nowadays we are using a lot of like mobile and a lot of exchange of messages are there, SMS, WhatsApp messages. So all these, into the eyes of law, we call them electronic evidences, which is governed by Section 65B of Indian Evidence Act. So there, proper formats and proper 65B certificate is there, procedure is there, how court should appreciate electronic evidences. But here, while collecting such SMS and WhatsApp messages, the ICC will hardly have a knowledge of how electronic evidence should be appreciated and how it should be recorded. If a printout of electronic evidences are given, they are called secondary evidences, secondary documents. So since in today's era, maximum cases are coming out of SMS, WhatsApp messages, or Facebook messages. So it's very important to understand the crux of it, the provisions of IT Act, and how these things should be appreciated. Not at the standard of court level, but at least at the standard of prudent man level, so that tomorrow, if the cases get challenged at higher court, the report of the IC should not be set aside merely on the ground of procedural infirmities. So that has to be taken care. Next, what I have found is there is lack of awareness amongst women employees about the act. Like ICC is there, but many women employees don't know. And even if they don't know, they don't take a courage to go and file it. They said, unnecessarily, I will become the talk of the town, so I should not go. So it is the responsibility of employer that awareness is created at such a level, and comfort is being given at such a level that women employees should be encouraged to come and file a complaint. And for filing a complaint, they should first know that there is some mechanism like this which exists, and where my grievance will be redressed without any bias. And no, she'll not be harmed in terms of her employment and in any other manner. So that awareness women should know. So for that, regular sessions, regular interactions, probably in a very comical or other ways. Nowadays, lot of innovative ways people have come across where informations can be circulated in a digital form or in any other form. So I find that not a committee, since committee has obligation to conduct the inquiries and promote awareness, so somehow they come across information, but women employees in general who are busy with their work hardly comes to know about it. One more issue which I would like to cover here is, since this act of sitting in ICC, conducting complaint and all this, the employees are usually busy with their day-to-day duties, discharging their official duties in day-to-day life. So this ICC thing will never reflect in their, what we say, uh, their targets. So this is one of the additional activity on them. So it is duty of employer that people who are burdened with other things should not be given the responsibility of ICC. And even if they are given, they should be given sufficient space in their own day-to-day official discharging duties so that they can accommodate this thing as well. And they should not be considered as additional activity, but very integral activity which is integral to the functioning of the organization. So that space and that should be given to it. And moreover, the biggest challenge this act currently has is currently it does not cover sexual harassment of other gender. The act is very clear. It says any sexual harassment faced by women only. So any harassment caused by men to women, that is covered. Women to women is also covered. But for other judgment, for other gender, which is being like in today's era, the definition of gender is getting expanded. The third gender, LGBT, the LGBTQ community, and they are not getting ample space, and like they are not covered under this act. In future, if the act gets amended, it is there, but as of now, there is no provision for them. So this is quite a limitation. This act. Then we also have to understand that this act uh, offense, like they say that the offense of sexual harassment under this act is a non-cognizable offense. Section 28 very clearly states out that. So anything ensued from this act, it will go as a non-cognizable offense. So for if it is non-cognizable offense means a complaint has to be filed before magistrate and will be tried by judicial magistrate first class, and it's a bailable offense. So I think with that I'll end my session, and thank you.
Thank you so much, sir. That was extremely interesting. If you don't mind, can we open the floor for questions?
Yeah, thank you.
Thank you. So, if anybody has any questions, you can please put them in the comments. If there are any questions, you can just put them in the comments. If you don't mind, maybe we can wait like 10 15 seconds,
No
10
problem.
15
No
seconds.
problem. No problem.
So I don't think there are any questions for now.
Okay.
So maybe we can just end. But before we do, I would just really like to thank you for taking your time out and contributing to this project. It really means a lot to us at here at LawSikho as well as to all of our viewers. Thank you so much.
It's a pleasure.
Thank you so much. I'll
Thank
just
you.
end the streaming.